So with this, let us directly move into our first panel. Thank you very much for joining me over here. What human rights issues do we face due to enhanced connectivity? So I think we heard a very good example just from these bringing us into this panel, an example of positive use of technology for human rights implementation tracking. But also we want to discuss downsides of the rapid growth of digital opportunities. The development of increasingly advanced digital technologies has enhanced the capacity of states as well as of private actors to conduct surveillance, interception, and data collection activities. Human rights bodies have somehow adapted to the digital age, with a key role in advancing legal and governance frameworks for the use of such technologies by governments and companies. Now I have three excellent speakers with me for this panel today to discuss this topic. Nigat Dad is a Pakistani lawyer, a founder of the Digital Rights Foundation, a non-profit organization focused on cyber harassment, data protection, and free speech online in Pakistan and South Asia. And also she's member of the Facebook Oversight Board. Thank you for being here with us today. To my very right is Yuval Shany. Professor Shany is the Hersch Lauterpacht Chair in International Law and former Dean also of the Law Faculty of the Hebrew University of Jerusalem. And he also served as a member of the Human Rights Committee from 2013 to 2020, being its vice chair from 2017 to 2018. Additionally to this, and we are very happy about this, Yuval is teaching here in Geneva, both first at the faculty of the Geneva Academy and now also at the Graduate Institute. My immediate right, Peggy Hicks, thank you for joining us. Peggy Hicks is Director of the Thematic Engagement, Special Procedures and Right to Development Division at the UN Office of the High Commissioner for Human Rights, where she provides strategic direction to the UN Human Rights Office work on a broad range of pressing human rights issues, I would say, but including, of course, on human rights in the digital age and expanding civic space. Before that, you were also director at Human Rights Watch, Global Advocacy Director at Human Rights Watch, managing Human Rights Watch advocacy team and providing direction to the advocacy worldwide, which of course also linked a lot to the topics of today's discussion. Now in the program, you will have seen that we have some overarching questions about what the human rights work is applicable to the development and use of surveillance technologies, the human rights standards that should regulate data collection, storage, and use, and also how the human rights framework can be made applicable to private actors such as surveillance and tech companies. We asked what the human rights safeguards are, including but not limited to the right to privacy that would need to be strengthened actually in the context that we're discussing today. And finally, also how digital connectivity and transparency can help counter government overreach in instances of surveillance, interception, and data collection. But Nigat, if I may start with you actually and turn to you. First question to you, are human rights standards the guideposts for industry, or is it rather a multitude of community standards and ethics? And where do you see also the obligations of states and where are the responsibilities of the digital community platforms in that area? Please, Nigat.
Yeah, well, first of all, thank you so much for having this conversation here. And I would really like to commend Geneva Academy of including voices from global majority in these conversations. Because in my work, what I have been advocating for years, running this non-profit organization, Digital Rights Foundation in Pakistan for a decade, that our voices should be included in, especially in places where these conversations are taking place or some big decisions are being made. And this morning roundtable was really important to also note how different tools are actually being made and being made accessible to the groups, not only the global north, but how global majority can access that to hold their governments accountable. And also seeing how recommendations, especially for instance, UPR, and I'll talk about UPR because Pakistan is going to be under review in upcoming November and December under Universal Periodic Review. So how important these tools are for groups in the global majority. So first of all, thanks for having this space for us. With regards to the digital platforms and how they are sort of looking into the international, actually not really looking into the international human rights framework. It's, I think, different bodies who are holding them accountable to look into the international human rights framework when it comes to their community guidelines, or how they are looking into different aspects of the platform, for instance, content moderation. And that's what my role is at the Meta's Independent Oversight Board, to hold Meta accountable around their content moderation decisions. But I think it's one thing that we have been doing at Digital Rights Foundation for a decade, before becoming part of this oversight board, was basically holding these platforms accountable in terms of the uneven response to the communities that use these platforms, based depending where they are based, whether they are in the global north or they are in the global majority, or where their profits matter. And I think what we have seen over the years is that different organizations from different jurisdictions have been holding them accountable in a way that if you are responsible and responding to the governments, for instance, in US, they are going into the Congress and responding to the, Congress people, senators. That's not the exact way they are able to respond in our part of the world. And I think that's the uneven response we have been seeing by the platforms. And for me, over the years, it's not only looking into the context of different jurisdictions and how companies should take those contexts into account, but also how international human rights framework actually give a solution to these platforms to look everyone equally who are using those platforms. And I think that's what we are trying to do at the oversight board, applying international human rights framework of freedom of expression and telling company that where they are wrong and where their community guidelines are wrong, and holding them accountable in terms of making right decisions, and our decisions are binding on them. So these self-regulatory mechanisms I believe are very important for these platforms. Besides all the other things that we are doing, there is no one solution to hold them accountable. There are different solutions that we have to try out. There is one company which is doing it, but there are so many other companies who are not even do not even respond to the different concerns being raised by multi-stakeholders. And I think we should be very, very concerned about the companies that are coming from the jurisdictions where the human rights law itself is jeopardized. And I'll add into the conversation when my other speakers will talk.
Thank you very much, Nigat, for that first intervention. And if I may turn to you, Peggy, last month your office communicated about the recently released report on the right to privacy in the digital age, and the headline was "Spyware and Surveillance Threats to Privacy and Human Rights is Growing, UN Report Warns." So what exactly is growing, and how? Is it the growth in technical possibilities, or is it rather also growth in the use by governments who shy away less from maybe using what would have been technically possible for them already? So over to you.
Either way. Great, thank you. No, thanks for the question. It's such a pleasure to be here with Yuval and you guys, and you, Felix, to talk about these important issues. Well, the easy answer is that it's both. I mean, the reality is, as I'm sure you've heard, and we heard a bit from Lisa, the tools that exist and the technology that we're dealing with continues to evolve in exciting ways, but also, depending on which end of the spectrum you're on, frightening ways. And the reality is that the regulatory accountability response to that is simply insufficient. And there is a natural tendency when you're faced with problems to try to want to throw a technical solution at them. But the reality is the guardrails that we need on how that is done, especially when these technologies have substantial human rights risks, are simply not in place sufficiently. That said, it is also the case that we've seen in our report evidences just a growing reliance on these tools by a broader range of governments than we were aware of. And that, of course, came out very strongly in the revelations around the Pegasus spyware. Obviously, Pegasus isn't the only tool that's used in this way. Kanduru and others are also engaged. But the extent to which the governments that were deploying these tools and who they were deploying them against, including journalists, political opposition, human rights defenders, a broad range of people, was very shocking, as it should be. What's even more shocking is we all learned that, and if you ask, what has been done to actually address it today, the reality is not so much. And just the governments that were directly engaged obviously have had to, been hauled into account and had some hearings around what has happened. But in terms of the legal regime that's in place regarding this type of spyware, we haven't seen the types of developments that we need. And that's why our office in this report and elsewhere has called for a moratorium on the sale and export of this type of spyware technology until those guardrails can be put in place. And the report that you mentioned on privacy has a long section on that talks through what some of the recommendations we have on it are. But the reality is, for all of these tools, we start with the human rights framework, which imposes very strict and understandable, applicable rules as to how governments can deploy this type of privacy invasive tool. And we need those safeguards to be in place and respected by governments. And that means that they have to show that there's a legitimate purpose. They have to define how they're using it and use it in a proportionate way based on necessity. And there needs to be, accountability for how it's deployed with the ability of a limited time, purpose, and transparency around the deployment of those tools, and of course non-discrimination in terms of how they're used. So we need those sorts of constraints in place if we're really going to move forward on this. The report also picks up two other key areas of importance relating to surveillance technology: the need for end-to-end encryption and how important it is for a digital space that is rights respecting. And how concerned we are about some of the attempts to maybe undermine end-to-end encryption in a variety of ways. And then finally, it also looks at issues around mass surveillance, use of surveillance in a broad-based way through a variety of techniques. Of course, one of the most common being just the ubiquitous public cameras everywhere, where that information is going and how it is used without prior notice or judicial intervention of any sort. And then also the use of social media intelligence by governments, how governments are using everything that we say and do in ways to gather information far beyond what they ever knew about us before, and how that is all happening in a very unregulated space. The bottom line is, of course, governments need to put in place constraints to protect safety and to engage in ways that fulfill the purposes of government, but they need to do that in a transparent way that really takes into account the human rights framework which they have agreed to, and apply it to digital space the same way that they've applied it offline.
Thank you very much. Thank you for the short and the somehow longer answer, and definitely also something that will come back into a second round in the discussion. If I may turn to the third speaker, to Yuval, Shany, are human rights mechanisms using the right definitions, and can we update actually the rights? You've been writing also on new e-rights, so are those the solution to address state and non-state actors' practice of constant surveillance?
Right. Thank you, Felix, and thanks to Geneva Academy and all the other co-sponsors for organizing this very impressive conference and for inviting me. So very pleased to be here on stage with the other panelists, with Peggy and Yuval. So are human rights fit for purpose? That's, I guess, that's a perennial question that one is also always has to ask oneself. And I guess the answer is always yes and no. It is a framework and it is a benchmark, and it does provide us with a starting point, but arguably it doesn't provide us necessarily with the end point. And we have seen throughout the life of the human rights movement a constant efforts to basically redefine human rights, refine human rights definitions, but also develop, when needed, new concepts of rights and actually new rights to confront new challenges. And we have seen this in the movement towards greater specificity with regard to children's rights, women's rights, indigenous people's rights. Although, these rights could have been at some level extrapolated from the general rights we have for principles of equality and the like, it was found very useful actually to spell out very specific obligations, to generate discourse about very specific practices, to build capacity among government officials, international bodies, academics, civil society, and the like, around very specific notions, but also a time to, in a way, move the envelope, so to speak, and develop new concepts, such as, for instance, the right to clean, healthy, and sustainable environment that we have seen developed within the human rights mechanism actually quite recently. And I think that there is a case to be made that a similar line of reasoning could apply, even, I would dare to say, even more forcefully with regard to the advent of digital technology. And that has to do with the speed of the change, which puts considerable pressure on existing definitions and on existing capacity. But also the radical power implications of the changes, which do create some very dramatic challenges to basically human rights and human welfare. Maybe I'll just, to illustrate, just mention one dimension, which I think is central to our discussion here, and this is the permanent state of being in an on status. Okay, the fact that we are constantly online, and as a result, we constantly interact with information systems that collect data about us and about our movements and about our choices 24/7. So this is the ubiquitous and constant data collection, which writers such as Shoshana Zuboff have been writing about, and termed surveillance capitalism. But I would like to basically stipulate that what starts with companies, as we have just heard, often finds its way also to governments, and that there could be some context in which companies are part of the problem as much as governments. So I would like to stipulate that this situation of being constantly under surveillance. It can be the cameras, it can be the phones, it can be our computers, it could be the IoT equipment that we use. This actually creates a situation of social control that we have not seen before in human history at this extent, at this level of intensity. So there have been quite a few writers who have basically analoged the situation to the Bentham panoptica, to the idea of being constantly under surveillance. And this is, I would stipulate that this is a new human condition. And I think there would be some significant questions whether we have, within the existing definitions, privacy or liberty, we do have enough granular contents and sufficiently specific guidance to help us deal with this sort of situation. I can maybe in the next round, I can elaborate a little bit more on what has been happening. I could just maybe just 2 sentences. I would note that we have seen some movement already to deal with some of the implications of this state of constant surveillance. But the movement that we have seen so far has been very much focused on governments. And I think that this is perhaps symbolic, or this is symptomatic of the broader question, and whether we do have in place the suitable enforcement or suitable monitoring infrastructure. Maybe monitoring is not so good term in this context, but do we have the apparatus to actually protect human rights? When governments, which is the traditional target for our efforts, may not be in the first line of the problem that we are dealing with, and we need to think of new ways. I think the Oversight Board is actually a very interesting and important approach to deal with one aspect, which is mostly content moderation with regard to two important services, but it's a bit of a drop in the ocean, like we've heard. The question: do we have in place an apparatus to deal with the broader features of being in a constant on position? I would argue that we currently do not have this apparatus, and more troubling is the fact that we do not have actually a very robust discourse concerning the need to have such an apparatus, and not in 20 years or 30 years, but right here, right now. So maybe I'll stop here and we can return to these themes later.
Thank you very much, Yuval. And I indeed have a couple of follow-up questions to you, but I also would like to open the floor and ask for your questions and comments here in the room, but also for the people who are following us online. I know many people registered for participating online at this conference, and as we're in a webinar setting, I'd like to ask you to send your questions via the chat, and my colleague Domenico Zipoli is monitoring that chat and will bring up the questions also to the panelists then in the next round. But maybe if I can, so while you prepare your questions and raise your hands and the colleagues bring a microphone to you, I would also maybe come back with one direct follow-up to you, Yuval. If such a new right would be declared, what would you see in terms of how this can help overcome those issues that we see now in surveillance? Like, do you have examples maybe from the parallels you mentioned from other rights recognized? Can that be the game changer? Where would we go?
Yeah, so I think, well, I actually have a very good, a very immediate parallel, and we have talked about facial recognition. So with regard to facial recognition, we are seeing the beginning. I mean, I think there would be a general consensus that facial recognition does raise very serious problems from a human rights point of view. I think most of us would put it under privacy, although I would argue that it's not just privacy. I mean, privacy is important, but we are often thinking of facial recognition especially in countries with more authoritarian governments in other contexts. I mean, not just privacy. It's also about political freedom. It's the ability, it's freedom of expression, it's freedom of assembly. So in a way, shoehorning these issues into one mega right, which is privacy, for me at least, may be part of the problem and not part of the solution in how we conceptualize, and we need to be more precise. So with regard to facial recognition, we are seeing the beginning of, I think, awareness to the need of generating specific norms in this question, in this regard. And we have seen last year, the European Union published draft AI regulations that tackle specifically the issue of facial recognition. But this, again, this is symptomatic, I think, to the claim that I was making. I mean, the focus of the regulations, the draft regulations, is the use of facial recognition by law enforcement in a very specific context, which is remote and public. But if it's not remote, if it's not public, if it's not law enforcement, if it's not the government, then according to the norms that we currently have, arguably, there is nothing wrong with it. Maybe we need to have a discussion. Okay, maybe we can develop the right to private or the other rights. Maybe we can identify, but we have not yet in a way, clarified, crystallized what are the norms that would be applicable with regard to one specific manifestation of constant surveillance. And I would argue that we need to engage in this work, and we need actually to tackle the very, we need in a way to grasp the bull by the horn. I mean, not deal just with the specific manifestation, namely that we have governments that are using this. I think we need to ask ourselves the bigger questions. Do we want to live in a society where every movement that we are engaged in, every conduct that we undertake is being actually or potentially tracked? And it could be tracked by a company, it could be tracked by a government. And in this regard, I think developing new concepts such as a putative right not to be subject to constant surveillance, I think could go some way in the direction of helping us focus our attention and our activism and our intellectual efforts towards how do we ensure that these structures are actually conducive. So I'm very sympathetic for what we heard by the keynote speaker about the right to connectivity. And I think it's a very important, it should be recognized as a human right. It arguably is in the process of being recognized as a human right. But I think we should also be mindful of the right to disconnect. And we have seen the beginning of a discourse on the right to disconnect, but also in a very specific context. So the EU, again, the EU Commission Declaration on Digital Rights and Principles for the Digital Age, they do talk about a right to disconnect, but they have in mind, again, a very specific context, which is the context of work-life balance. The right of employees not to receive emails in after hours, which is, of course, we know it's very important. It's very important for all of us, but it's in a way dealing with the tip of the iceberg and not with the iceberg. Maybe I'll stop here. I think Peggy had something to say.
Thank
she was shaking her head.
Yes,
when
so
I said
Peggy,
that.
just turning to
Yuval
you
and
two.
I have had a good discussion on this before, and there's so much of what he says that resonates with me. But I did want to come in on a couple of points. Yuval, one of the things that really I think is absolutely true in what you say is the fact that the apparatus is not in place. That I think we can agree on 100%. You know, the reality that only Meta has the oversight board and that the other companies, you know, are not even at that place, and that it's only its own invention as opposed to a regulatory invention that's even making that happen. These are all huge problems. So the accountability mechanisms, I 100% agree, are not there. Where we disagree is around the need to really spend our energy and focus looking at what isn't already covered by the human rights framework. I've always argued that there may be things that the human rights framework won't get to, but we've done, you know, maybe a tenth of what we can to apply the existing human rights framework. And to me, especially in an environment where we are so outmatched in so many ways, we need to devote our energy to applying the framework we have. You're right that the right to privacy can't be the grab bag for everything, but that is why we have the other rights. And that is why the human rights framework is the best place to start, because we can mix and match and use all the existing rights. And the idea that the way to solve that problem is to add in another right, to me, just, you know, doesn't get us where we need to go. So I have a lot of empathy for the idea that we need to really do a huge amount of work to develop how the existing human rights framework can help solve some of these problems. But I'd like us to start there. And I do think the piece of it that's not recognized as much as well is around how the UN Guiding Principles for Human Rights are not just about companies. They impose upon companies responsibilities to respect human rights, but they have a whole pillar that's about the government's obligation under existing human rights law to actually make these things happen. And if governments were living up to their obligations under the UN Guiding Principles on Business and Human Rights, we would have a lot less to talk about in panels like this one.
Thank you very much, Peggy. And well, a follow-up question to you will be, but maybe in the next round also, how concretely, I think you spoke about the framework, but also how the human rights mechanisms, which are the main target also of the work of the Geneva Human Rights Platform, how they can practically also give more guidance and approach those points that you just mentioned. But I think maybe you'd like to also react, Nigat. So of course, the oversight board was mentioned several times. So maybe on some challenges and progress also you see on that, but also as we just heard, and you were nodding about the state pillar of the UN guiding principles, if you'd like to have a word on that.
No, I completely agree with Peggy on this, because the guiding principles laid out by the UN, it's actually a good starting point, and we have seen progress around those principles over the years. Even the upcoming 11th UNGP forum happening in Geneva in November has positioned rights holders and accountability as central elements of the state duty to protect and the business responsibility to respect human rights by emphasizing access to remedy with effective judicial mechanisms. So we see that there has been progress there. I think why I was basically nodding head, because there is an imbalance in the way we are progressing as a world. You know, we are talking about new rights, but we are not talking about the jurisdictions which or the governments and states that are not respecting the rights that are already there. By the international human rights framework, the treaties that they have signed, the conventions that they are part of, not only signed but ratified. And I think for me, the biggest question is how we are holding those nation states accountable. They are coming up with, and we are talking about regulatory framework around digital platforms, but also, you know, providing rights to the users of these platforms. But at the same time, whose rights we are talking about? And I think that for me, that's a very uncomfortable feeling, that one part of the world is moving ahead very quickly around these regulatory frameworks. So we are seeing EU coming up really progressive laws, which is really good. But at the same time, I'm seeing different jurisdictions coming up cybercrime laws, and they are not there to stop cybercrimes. They are there to actually monitor and surveil users on the internet. And who is holding them accountable? Who is holding them accountable in terms of the international human rights frameworks and treaties that they have signed and ratified? So I think for me, that's also a question, that how these regulatory frameworks are being enacted in different jurisdictions, and the inequality that we usually talk about around connectivity or digitalization is basically enhancing. We are not bridging those gaps. So we really need to bring those conversations, part of these conversations as well. With regards to the oversight board, I agree that this is just a drop in the sea. This is a very small solution around content moderation. We are not there to solve all matters problem. There are so many problems, and it's just the content moderation that we are looking at. But I think there are successes there, and also under UN guiding principle, it's also not only looking into the principles, but also how to bring civil society and different stakeholders part of the conversation. That's what we are trying to do at the board. And I personally believe, you know, working in the board for the last 2.5 years, I think that we have set a good precedent for the other companies to look into such self-regulatory mechanism alongside the regulatory frameworks as well. In just last month report, in one of our decisions, we told Meta to do a human rights assessment report around Palestinian users and how they are facing hindrance on the platform around their exercising their freedom of speech. And it's not just board recommended that, but several civil society organizations have been pushing company to do such kind of audit. And they did that. So there's this, they commissioned the report to BSR Human Rights, and the report is released after 1 year of, you know, working on the report. And they found that, yes, there were violations of Palestinian users. So I think this is a small success, where an independent oversight board pushed the company to conduct such an audit. And the company came up, it's an independent report, but they are now looking into the recommendations that the report is given, but also listening to the civil society organizations, listening to the board, But I think the challenge is how much they will implement these recommendations. The transparency around this is very important. For us as a board is very important. And we are also holding ourselves accountable to the audience who are the watchers of the board. Hold us accountable. We are releasing our transparency reports as well. And in those reports, we are telling people what kind of progress we have made so far.
Thank you very much. Thanks for that. And I think, again, to the discussions we had this morning, it was about transparent tracking of implementation of human rights obligations of government. But of course, there might be also tools that could also then source and check and track about the implementation by companies such as Meta of this output. I think there's actually also a parallel to be drawn. Again, to invite comments from the audience now. So I will not directly go into a next round, but see who'd like to get some pass. Yes, so there is microphones. Yes, and so Peggy, please. You've been speaking before to the others too. When you take the floor,
yes,
just
I think I just want to echo Peggy's sentiments. I have worked in this space for some time around Africa. And if you even look at how long it takes developing countries, especially those from Africa, to even have the right legislative framework, to have the right policies, to strengthen their institutions, which are supposed to play a key role in really enforcing the human rights challenges, I believe that, you know, we can make a lot more progress when we look at what we already have. And then we see to what extent, because the traditional human rights, yes, there may be situations where what we have may not be sufficient. But I believe that even with the rights that we currently have, looking at it through those lenses and seeing how people are behaving online, we can clearly identify where the violations are. The question then for maybe our countries, maybe civil society, for everyone is, are we doing much to make sure that we're protecting the interests of the people? And I will give you an example. In my country, our governments have for some time employed the use of Pegasus. Okay, there are rumors that it is being used to survey, but it is very difficult. Sometimes even civil society has limited resources to push for the enforcement. In communities that have very weak institutions, it's extremely difficult to get or hold either the companies or even government itself accountable in ensuring that. So even if we go ahead and we define a new right, you know, those challenges will continue to persist, and people coming from my communities will continue to be violated. So I'm just saying this to say we should also start looking at what can we do to actually ensure that these issues are implemented and people are actually protected, even with the laws that we have.
Thank you very much. Again, the question implementation, realizing the existing obligations. Yes, please, and if you could introduce yourself, please.
Alev Mine of the One Goal Initiative. For Yuval, I would like to, approve of your demand to be able to disconnect, and I would, raise it to being able to not be identified with a given identifier while connected. There's a huge effort right now from certain companies or parties to become the provider of the unique identifier of a person, and that entails some human rights risks, and I would suggest that it should be made possible for people to not be identified by any specific identifier, while not losing opportunities or possibilities for services or anything like that on the internet. And I would like to suggest to Felix maybe to have a further event where the quantum aspect is included with regard to human rights.
Thank you very much. Do we have further requests for the floor in the room? Yes, at the back of the room, and then we'll come in the next round to the questions online, if this is okay. So we'll just first collect here in the room. Yes, yes, please.
Hi, Ben Greenacre, formerly advisor to Dr. Shahid, UN Special Rapporteur on Freedom of Religion or Belief, now at the Geneva Academy. So first, I just wanted to echo what Peggy said. I think it's an incredibly dangerous time to talk of adding new rights to the current pantheon, opening up treaties for discussion, or talking about the negotiation of new treaties is perhaps unrealistic, and opening existing treaties is maybe a particularly dangerous time to do that. And I think related to what we're discussing today, I think that's been seen with the Secretary General's panels on neuroscience and human rights, and was something that was echoed there. There's a big push for the discussion of neuro rights as a separate entity to human rights, but neuro rights are human rights, as is sort of freedom from surveillance and everything. And I think our current building blocks are sort of more than enough to establish this right. They just need to be enforced and pushed. And on that, I sort of have questions regarding interesting ways that we might pursue enforcement. We've mentioned surveillance today. I think of the 5 most well-known companies that provide sort of private signals intelligence capacity to countries. All of them, I believe, are located in the OSCE, and only one has received any kind of investigation or sanction from the government. I believe that's Hacking Team of Italy, whereas obviously NSO Group, infamous Pegasus, has sort of received absolutely no public investigation from the government of Israel, and has really sort of just shut down shop and reopened under another name. So maybe looking at interesting ways of extraterritorial enforcement. I think I have the same question with regards to digital colonialism with the data extraction in sort of outside of Western Europe. I mean, Facebook Basics program was a particularly onerous example where these large digital tech companies were leveraging their sort of preeminent global position to provide internet services to developing countries, but obviously extracting all of that data in quite a discriminatory way that would generate behavioral surplus for marginalized or marginalized communities within developing countries, but also developing countries as a whole in a way that just isn't present in Western Europe. So maybe the panelists have some views on creative ways of extraterritorial discussion under either states' obligations or other legal frameworks. Yeah, lastly, I think this was for the rapporteur, who is not currently on the panel, but I would be interested in hearing more about specifically how AI and machine learning have been integrated into these civil society platforms to promote human rights. I mean, obviously AI and ML is quite a vague term, a broad constellation, as David Kay called it. So, I mean, what specifically are we looking at? Are we looking at web scraping tools that then use sort of ML to pull together and paste that on a civil society website? And that sort of, as somebody who worked with HurryDocs actually on one of these websites, the burden to civil society of their ongoing updating is significant and not to be underestimated. So I'd appreciate a little bit more detail on what specifically we're looking at when we say AI and ML integration into these platforms. I do have other questions, but I'm cognizant that other people want the floor, so passing it along.
Thank you. Thank you very much for your questions. Do we have further requests at the moment in the room? Maybe yes, so one more, and then I'll give it back to the panel also to react to those various points.
Thank you for the discussion. I just wanted to react a bit to the issue of connectivity and the right to disconnect. I find it quite interesting. And I wonder whether the human rights framework can also help in that direction, because I think what we need is to find a good compromise I could just refer to the use of energy, or the addiction is created and health issues in relation to that. So I would like to hear your feedback. Thank you.
Thank you very much. And so I'll turn back to the panel. Maybe I'll start with you, Yuval. We had also the question of enforcement of implementation or innovation, and I think a number of questions also addressed to your interventions. So first of you, and I'll come to all the speakers of the panel.
Yeah, I mean, there have been very good points which were raised from different directions. Let me try to say a few things in general about this. Is this the right time to create new rights? I think this is always a question for human rights lawyers. I mean, human rights have never, I mean, since they were embarked on at the international level, they were never static. I mean, they were in a process of constant development. And I think part of the success of human rights in capturing the imagination and in improving the lives of many millions of people around the world has been the ability of human rights to continuously evolve and to respond to new challenges. So we are talking today about indigenous peoples. We are talking today about environmental rights. We are talking today about persons with disabilities. And I would submit that we wouldn't be having the same conversations had we not developed new norms. Now, developing new norms doesn't mean that we throw the old norms out of the window. The old norms are the framework. They are the basic layer. The question is whether we want to develop more specific norms that would actually put flesh on the bones of the existing norms and render them more concrete and more fit for purpose. And I would argue that in this field, I will make a general claim that in this field, there is a pressing need because of the speed of the change, because of the drama which is associated with the change and its implication for the division of power around the world, because of the irreversibility of some of the technological developments in this, well, it would be very difficult to turn back the clock. So these surveillance capitalism structures are already so much embedded into our society. So even to think about reversing them is going to be a very heavy lifting. And now we're talking about AI and relying more and more on AI. This is the time actually to develop the norms about AI and not wait 20 years when AI is all around us or the next or metaverse or what have you, and then start thinking about, okay, so how do we reverse engineer this? It's very difficult to reverse engineer in this field. So that would be my general claim. I would also claim that this is not an abstract discussion. I mean, because norms are being produced all the time in this field. So it's not like that we have a button that we can suspend the creation of norms. So the AI regulations by the EU are in the process. The White House issued 2 weeks ago a blueprint for AI principles, which is actually quite interesting and quite impressive. But that's only a blueprint, and this is moving. We have the GDPR, we have the DSA. I mean, we do, which also deals with some of these issues concerning data collection. So there are legislative processes which are taking place at least on the national and regional level. And there is a question whether the international, the global human rights movement wants to weigh in on this, on these discourses, on these discussions, and ensure that the angle, the concerns of human rights are being specifically addressed, not in general terms. And I would also want maybe two more things, and then I will surrender them. One is that we are dealing here with, the fact that we have companies central to the process makes lives difficult because, this is not the same repeat players that we've had within the discourse. So when we are telling a company you have to meet Article 19 of the ICCPR or Article 20 of the ICCPR, in a way, some of these companies, some of the developers are newcomers to the discussion. And I think in order to engage them with the discussion and also to engage the engineers in the discussion, who are a class of actors who were previously not as much engaged in human rights discussions, I think you have to bring the principles down to earth, and you have to articulate specific concerns and specific needs, and sometimes identify that this technology is an unacceptable technology, and not leave it at the generalities of legitimate purpose, proportionality, like we lawyers are used to do all the time. If we want an analogy, and I'm looking at Gloria and in the corner, I mean, in weapons control, we have done similar things by actually identifying specific weapons that we want and we don't want to have. Finally, I wanted to say something on implementation. We do have some interesting precedents. We did see some of the special procedures broadly understand their mandate as also including the monitoring of companies. We have seen special rapporteurs accept complaints against companies for violating human rights. I think this is an interesting approach, and I think it would be interesting maybe also for the Geneva Academy to think whether this anecdotal practice can be generalized and can be made scalable, and to see under what potential we have within the existing system to deal more effectively with this huge gap in accountability, which, notwithstanding the guiding principles and their important role in pushing the discourse forward, we know that this is part of the journey. It's not the end point of the journey, which is partly why we're having negotiations for a convention on business human rights, because we know that where we're at is not good enough. So I would make this claim that we can maybe within even the existing institutional infrastructure do be a little bit more ambitious in how we engage the private sector.
Thank you very much. And now we have also already, as I said, the annual conference is a moment for us also to project what to do. So we have a suggestion of a research project and of a conference. So I'm taking notes of those. But also Yuval spoke about the existing framework and using that. So I think that's also what resonated with what you have been saying before. So giving the floor to you also to react to those comments, Peggy.
Thanks. No, for the comments. It's a really interesting conversation. I'm sure we could be here for hours, but I think we only have a few minutes. So I'm going to try to keep it brief. 3 points. Yuval and I think we should make it clear that this is really a disagreement about tactics, not about purpose or mission, right? My sense is, Yuval asked the question, don't we want to engage on these debates around the DSA? Absolutely. We have been. We've written a letter that was, I hope, influential in some of the deliberations around Europe setting forth how the human rights framework ought to be incorporated within it. We engaged in hearings and other processes around the DSA, and the DSA reflects human rights principles the human rights framework in a very substantive way, I think. And that's what we want. We want these documents to all say, we are already bound by a set of human rights law, and we will bring that into our regulatory efforts on the technical space. And when they do that, I think we get there quicker with the best results. If we open the door, it's both, the timing issue is interesting because you bring up the speed as the issue, but the speed to me operates the other direction, where because things are evolving so quickly, we really need to use what's at hand. And even then, the reality is I think we're falling behind. So it's a tactical difference, but I think there is plenty of space for us to use what we have to engage effectively in the ongoing debates. I wanted to go back to Nijat's point about the differential between engagement by companies, by governments, by all of us in terms of how we talk about these issues in the developed world versus the developing world, because it simply is something that we have to continually go back to. I really appreciated her point about the fact that what type of response you can expect from the company will depend on where you are. And that is absolutely true. The Meta Oversight Board decision that she refers to, I mean, there's a fundamental issue of language in there. Which language were people engaging in, and how sufficient were the content moderation tools within Meta for those different languages? If they're not handling Arabic and Hebrew well, you can imagine how they're doing in different jurisdictions in Africa where you have, multiple, even less prevalent languages. So the issue is, what obligations do companies have in these different jurisdictions? Our argument, of course, is whenever they make a decision to operate someplace, they need to devote a equivalent, sufficient number of resources that will allow them to do so in line with their human rights, their responsibilities to respect human rights under the UN guiding principles. They are simply not doing that. We need to really quantify that and make real demands and look for real commitments that will change that environment in terms of how much investment, how much they pay, basically, in terms of content moderation and translation and everything else that is necessary when they're doing business in different jurisdictions. And then finally, I wanted to go to the point that Yuval has made, I think, very eloquently around one of the things that's very different in this space is that so much of human rights has been focused on governments, and right now the companies are such powerful actors, and I think that's absolutely 100% correct. And I think that we really do need to engage with that. My own personal experience on the human rights side, going back to my Human Rights Watch days, is that when we engage with the human rights framework vis-a-vis companies, we have real potential to make change. We actually, sometimes companies can be easier and faster to move than governments for a variety of reasons that we can do a whole nother seminar on. But we need to invest in that space. We've tried to do that through a project called BTEC, where we're bringing together the big companies to really hammer down with them on what their responsibilities are, to look at the practical application of the guiding principles to digital technologies. And we need to do more of that. And we need to also put what we find in those contexts forward in a way that really pushes for companies to be held accountable. The issues around mandatory human rights due diligence, for example, are very, very important here and can make a fundamental change in how we look at this. We also need not just self-regulation by companies, but co-regulation. Broad industry standards on things will be much better for all of us, rather than having to understand what Meta's community standards are and what Google is doing and what Twitter is doing. We really ought to have a common baseline and hold them all accountable to it at once. Thanks.
Thank you very much. And Nika, I'd also give you a chance to react to the comments from the room, but then we'll hear also again in the last round the comments from questions from people online.
Yeah, very briefly, there was this comment around free basics, and what I would say is that companies are able to respond equally in different jurisdictions because of also how governments have, a lack of, like how they have responded towards providing, like protections to the users. For instance, I would say data protection law, right? So it's interesting to see how different regimes are moving towards making cybercrime laws that are basically there to control the content of the users and different ways to weaponizing those laws against users, especially dissenting voices. But at the same time, they are hesitant to make good laws like data protection laws. And given the example of, my own country and neighboring country, India, which is supposedly the biggest democracy in the world, we are seeing all those trends, where these laws are being weaponized against users. But that also gives leverage to the companies because they know that there is a lack of protecting mechanism and legislations, and they can do businesses without any accountability in those jurisdictions. GDPR is such a good standard, for the rest of the world to follow that. So why different governments are not following it? It's not that they don't have resources or they don't understand, it's the lack of will. So I think the way we are holding companies accountable, I think we in the same manner we hold nation states accountable as well, that why they are not doing the things that they are supposed to do. And when the good precedents are being set by countries who have good rule of law. And I would say that and countries actually copycat bad precedents very quickly. I'll give an example that although, you know, like we have a very interesting relationship with our neighboring country, India, but at the same time, we both, like civil society organizations, see how they both copy each other's bad legislation to actually monitor civil society organizations, and constantly shrinking the civic space, where human rights defenders are now unable to even raise their voice without putting themselves at risk.
Thank you very much. And if I can get some questions also from online, because we had, I think, getting questions and making people wait. So Domenico, if you could bring those to our attention.
Thank you. Thank you very much, Felix. There's quite a number of questions actually, and we have, what, 15 minutes, so maybe I make a selection of 3, 4 questions. So thank you to all the panelists for the many interesting insights. So the first question asks, why is there such a strong reluctance among governments and international organizations to introduce new digital rights? Is it seen as undermining the current human rights framework? Can't the two tracks be pursued in parallel, given the needs to provide new safeguards for the digital world? Then we have a suggestion. This is a question for the moderator, actually. At times it happens. Is the Geneva Human Rights Platform following up on and coordinating in any way with the Internet Governance Forum and the follow-up meetings of the World Summit on the Information Society, for which ITU acts as secretariat, in order to join forces and coherence in frameworks discussion and setting? And this person also mentions the UN Bioethics Commission, which facilitates discussion on UN agencies and programs, secretariat provided by UNESCO. Then there is a specific question for Nigat. So there's a statement first. So the purpose of the board is that of promoting free expression by making principled, independent decisions regarding content on Facebook and Instagram, and by issuing recommendations on the relevant Facebook company content policy. Could you please provide us with an example or two of how these recommendations are taken and the ways in which meta management uptakes such recommendations? And the last one I have selected here is a bit of a cheeky one. Is there an ongoing discussion taking place between Menlo Park and Geneva? And if so, is it worth it? Voila. So these are the four.
Thank you for the questions. And so I think in a closing round, we'll give those questions to you, also with the possibility to give also any other remarks you wanted before we indeed close in 12 minutes this session. And of course, for the GHRP also to pick that one up directly. So I think aside of one event that we had last year at the World Summit of Information Society, as I think it's indeed something that is really interesting to see how actually to expand our work. Because so far, the genesis of the Geneva Human Rights Platform was really the support of the UN human rights mechanisms, and we worked very closely with the experts in those mechanisms. But I think also special procedures, for example, have set very good examples by, well, not only talking within the system, but reaching out to other actors outside that system that seem to be in need of that input also from the human rights world. So I think it's an encouragement that also take away for us, given, well, that we also should enhance the outreach actually from Geneva, from the Human Rights Platform into those debates. But with this, well, if I go by reverse order, maybe starting with you again.
Yeah, sure. So in all our decisions, we have given 120 recommendations to date. And Meta has committed to implementing most of them. Actually, 70% of them have been implemented partially or fully. These includes developing and publishing a crisis policy protocol that dictates how emergency situations are handled and provides guidance not only to employees but users. This was published in part last month. The board is continuing to call more clarity and transparency around this. Another one is committing to publish informal government requests to remove content, and Meta agreed to notify users when content is removed by machines rather than humans. They agreed to translate community standards that Peggy has just mentioned and policies into additional languages spoken by hundreds of millions, such as Punjabi, and we have basically within the board a committee that monitors the implementation of these recommendations. So continuously within the board, we are seeing how Meta is actually implementing those recommendations. It's also the kind of recommendations we are giving is not something that they can implement overnight. There are structural flaws, in the design of the platform, and it takes actually time to implement those recommendations on a scale within the Instagram and Facebook. I hope this responds to the question.
Thank you very much. And passing the other microphone to you, Peggy, also for your reactions.
Thanks. I'm glad Najat raised the example of finally translating the community standards into Punjabi. That is indicative of the problem that they had been operating for a substantial period of time without that in place. It seems almost impossible to believe, but yet true. 3 comments. One is that one thing I think we have to really recognize in this space is that we don't have all the answers. The way that we best regulate this industry to be able to produce human rights results that take up the real challenges that Yuval and others have put onto the table. I think, there's a natural tendency to think that, if only we could change the business model or do something like this, we're going to solve the problem. We're not going to go back, as Yuval has said. We're not going to permanently disconnect all of us. So we do have to figure out how to work in this space and how to live in the space in a way that does protect basic human rights and dignity. And we need to be willing to listen and learn to be able to find those solutions. That's one of the things I like about the DSA, is that I think it will be a really important foray to help us look at what works and what doesn't in terms of how they've targeted the larger companies and the specific responsibilities of the larger companies and what they're going to do. But we have to be willing to look at, audit, and respond when things don't work as planned as well. And that can happen as well with a well-intended legislative attempt can sometimes end up having unintended negative human rights consequences. So we really need to be watching, auditing, and evaluating what works and what doesn't, and be willing to learn. The second thing I wanted to mention is I wasn't here for the full conversation around what are the tools that we have and how are we using data to better protect human rights, but I think there's tons that can be done in that space, and I'm really grateful that the discussion is happening. One of the things that I wanted to specifically flag that we recommended, we're talking about the right to disconnect, but we also have written quite a bit about the right to connect through the connectivity conversation, but also the fact that many of the activities that are happening to move forward on connectivity are with governments that are at the same time engaged in shutdowns, internet shutdowns in a variety of ways. And so we need to connect those two conversations and make sure that with assistance for connectivity comes some obligation that you actually do go forward with and allow all people in your society to benefit from that resource, even in periods of potential protest or other things where there might be a temptation to shut down the internet or to deny people access to particular services. And one thing that we've called for on that is that right now governments do not do much at all to say when they are doing things that we consider internet shutdowns, and that includes things like bandwidth throttling and other activities that don't rise to the level of a blanket shutdown. What we really want to see happen is additional standards around how governments have to be transparent about when they're imposing shutdowns and what the why they believe there's a legitimate purpose to do that and how it does comply with human rights law. And we see there to be a real need for compiling all the information that we have around shutdowns, and Access Now and other society organizations, the Keep It On Coalition, have done tons of work on that. But there's a real need for us to bring governments into that conversation and make them provide the data that they have, and companies as well. Ranking Digital Rights has reported on the fact that most companies are also not reporting on the things that they are doing with regards to internet shutdowns. So that's just one example of where we do have real data needs, and where our office has called for a consolidated information-based effort to address internet shutdowns. And then finally, I did want to mention the work that is ongoing. One of the questions related obviously to IGF and WSIS. It is really important to engage in all those other technical conversations. And we're very happy that there's a Human Rights Council resolution that has asked the office to look at technical standard setting processes, which are the type of ongoing processes that have a huge impact on human rights, but where human rights considerations are very not very present in the room and very difficult to integrate. We've talked to civil society organizations who find those processes opaque. They don't have the resources to cover them. We've talked to people on the technical standard setting side who say, yeah, we'd be open to hear more about human rights, but it's not our expertise. We don't have that information at hand. So what we really need to do is bridge that. It shouldn't be too far to bridge, because ITU office building is located directly next to our office building practically. So we ought to find a way to do it, but we need to bring technical standard setting into the conversation and find ways to make sure we're interjecting human rights into that as well.
Thank you very much. And Yuval, over to you.
Maybe the connectivity conference for 2024 will be the ITU and the OHCHR. I mean, why is there reluctance to develop new rights? And I agree with Peggy. It's really a question about tactic, not about. It's really about how you proceed with all the many constraints you have. And we may have to agree to disagree, like many other. On many other questions where there are different points of view. Nigat mentioned the GDPR. I would like to. I think the GDPR is actually an excellent example of how you can change the status quo. There was a status quo concerning data protection and the rights of data subjects, and that status quo was radically altered through legislation, through the introduction of new rights. Now, we normally don't think so much about the GDPR as a bill of rights, but it is a bill of rights for the data subjects. And what's interesting about the GDPR that it's not only within Europe. I mean, you do have Convention 108 plus, which is by the Council of Europe, but is open for signature for non-European states. And we are seeing states around the world, mostly at this point in time in Latin America, who are expressing considerable interest in adjusting themselves. And anyway, I mean, the model of GDPR is such that companies who are operating in Europe would have to, including the major North American companies, have no choice but actually to adjust themselves to GDPR standards. And I think this is actually a very good case study. Maybe there's another research project for you, for how you can actually change the status quo. The question is, are we interested in doing something as spectacular as the GDPR with regard to the issue of constant connectivity and constant surveillance? I mean, do we consider this enough of a problem? I would argue that it's a much bigger problem than the problem of data protection. I mean, the fact that we are under the permanent gaze of others. I think this is of course a discourse which would have to be engaged. What I wanted to say maybe in closing is that once you dig deeper into the issue of constant surveillance, there would then be more specific issues that would need to be discussed. So the person asked me before, the person who was here before, asked about anonymity. So this is, of course, a very major issue, and anonymity has its own set of issues, and it is currently subject to attempts by certain governments to dismantle anonymity, mostly around freedom of expression related issues. But that's one can of worms. And then you have the question of what to do with something we didn't discuss really, which is facilitated by constant monitoring, and this is social scoring, which again, the AI draft regulations do deal with social scoring, but from a government point of view, in regulating governments, what do we do with social scoring on a more wider societal level? What do we do with encryption, decryption? So there are many, once you open one box, there are many other, so it's like this matryoshka. Once you open the big matryoshka, there will be smaller matryoshkas which need to be unpacked. And just the complexity of the issues that we have to deal and the level of effort and persuasion we would have to engage in my eyes, makes it very difficult to tackle these issues using the very broad language of the existing rights that we have. And I think we would have sooner or later to become to go more specific. Maybe I'll stop here.
Well, thank you very much, Yuval. Thank you, Peggy. Thank you, Nigat, for your interventions, for that very interesting discussion. Thank you to those who asked us the question also and contributed to the discussion.